Failure to make the right disclosures when selling a probate house in Texas can expose you as the executor to personal liability long after the sale closes. This isn't a technicality, this is a real risk. Most executors don't fully understand what they're required to disclose, so let me walk you through this and try and make it as crystal clear as possible. I want to be very clear, I am not an attorney, but disclosures are something that I navigate in every transaction, and I want to make sure that as the executor of an estate, you fully understand the landscape. So in typical Texas real estate transaction, the seller is going to complete a standardized seller's disclosure notice. It covers major systems, utilities, any known or past defects with the property. It's a part of every transaction. It's a document the seller is going to have to complete and sign, and the buyer is going to have to sign for acceptance of. This is required by Texas property code. Now, Texas law does include a seller's disclosure exemption for probate property when the executor has not lived in the house. Because an executor never lived in a property, it's not reasonable that they could have full, real knowledge of the property. So the exemption does exist, but it is not a blank check. Even if you qualify for the disclosure exemption, it is still important and required to disclose any known defects in the property. If you know the roof leaks, if you know that there was a foundation repair, if you know the HVAC system isn't working, you need to disclose that. And this is where executors can get in trouble because they go, oh, I don't have to fill out a seller's disclosure notice. The exemption covers what you don't know, not what you do know. Using the exemption to avoid disclosing defects that you're aware of is fraud. And the most important part is what counts as knowledge for an executor. This is where it gets nuanced, right? If you found documents in a home that discussed a previous foundation repair, you arguably have knowledge. If another heir told you about a problem that existed with the property, you're probably going to be found to have knowledge. Courts have found liability in cases where executors claimed to not know things that were reasonably discoverable. The practical recommendation, many probate attorneys and probate experienced realtors would urge you to complete the seller's disclosure to the best of your ability, even if there is an exemption. Full disclosure protects you, it signals honesty to the buyers, and it dramatically reduces the risk of post-closing claims. Now, some people might say, what about the as-is language in the contract? This is where the buyer is accepting the property as is. These can somewhat limit buyers' ability to request repairs based on inspection findings, but it does not excuse an executor from disclosing known material defects with the property. As-is and disclosure are two separate legal concepts. So here's what keeps me up at night for executors that skip disclosure: post-closing litigation. A buyer that discovers after closing that there were defects that were covered up can sue. In Texas, real estate fraud and DTPA claims can result in damages, legal fees, and in fraud cases, actually up to 3 times damages. Cost of proper disclosure is zero, but the cost of not disclosing and potentially getting sued is potentially enormous. So if you're navigating disclosures on a probate property and you're not sure what applies to this specific situation, talk to a probate attorney and work with a certified probate realtor that specializes in these situations. I'm happy to hop on a 15-minute call with you and walk through your situation and give any insights from my decade of experience doing this. All of my contact information is in the description down below. While you're down there, check out the free Executor and Heirs Guide to Probate Property. Click subscribe for more daily Texas probate content, and I will see you in the next video.